Hello, colleagues, ladies and gentlemen. It's my very great pleasure to give you a very warm welcome physically from Santiago de Compostela. I'm amongst the few who have the privilege to be here and have the opportunity to show our gratitude to Jose Maria, to his excellent hospitality. But besides of that and all the friendships that we can live here, we are going to start with our panel A, and panel A deals with the sources for regulation at supranational level. We have three excellent speakers with three very, very interesting topics, and the way that we will proceed in our panel is to have the speeches first and afterwards have a debate. So I look around whether Tamas Gyulavari already appears on the scene. He will give a lecture concerning collective rights of platform workers, is on a special emphasis on the role of EU law. I can see you, Tamas, but I cannot hear you, obviously.
Okay, you do hear me. I didn't hear you.
Perfect. We can hear you, Tamas. I have already introduced you. I did not tell that it's a pity that for certain circumstances you cannot be here in Santiago as you have planned or we have planned. So, but in spite of all the difficulties that you had, I'm very grateful for the effort that you take to give us this speech concerning the role of European law, and the floor is yours.
Thank you, Franz, and I would like to welcome you all, but above all, welcome the IMF, the Impossible Mission Force in Santiago. Like you, Franz, and I really wanted to join you, but when else I should get flu than in June? Things are changing, so you can hear my voice. Sorry for that. I'm very bad at computers. I did my best to improve in the last 1.5 years, so thank you for my slides. As you can see, the title of my slides, I'm going to talk about the role of EU law, and as you will see, I will focus on the right to collective bargaining. Next slide, please. As you can see, I will divide my speech of 15 minutes, and I'm going to measure time. To save it. So I'm going to, sorry, can I go back to the slide before? So I'm going to cluster my speech into three groups. First, I will talk about collective rights in general, focusing on EU law. A second one will be the main part of my lecture, which is dealing with the role of EU law in terms of the right to collective bargaining. And of course, European Court of Justice, ECJ, will be the main focus of this part. And then I will try to come to very brief conclusions. Next, please. Next, please. Thank you. So the first part will be about collective rights for platform workers, and I will focus on the role of EU law. Next slide, please. If you look at this slide, you may remember the famous Bryan Adams song, All for One. And why is it here? Why is this picture here? Because the Musketeers, they had the culture, they had the know-how, how to cooperate, how to unite, and how to get better working conditions for themselves. So I take this example of the Musketeers, at the beginning 3 of them, and then a solo entrepreneur, D'Artagnan, joined them. So they show us how to do collective bargaining. But of course, I know the situation is different in the 21st century, because now you would have to go on the app musketeers.com, and then you get an offer Your task, if you accept it, will be tomorrow in La Rochelle. Please do not forget to bring your own equipment, your horse and sword and so on. And of course, in their time, transmission of information happened through horses and now on mobile phones. So I will have two questions regarding the musketeers. My first question will be in this section, why collective bargaining, why collective rights in general are useful and essential for platform workers. And the second will be which collective rights could be used from EU law. Next slide, please. So why collective rights are important, essential? And I compare this with flows and backdrops of platform work. So starting with the problem and answering with one feature of collective rights. The first, working conditions are infamously bad in platform work. Can I go back to the slide before, please? Thank you. So I will tell you when to turn on the next one. So the working conditions are quite bad in terms of platform work. So collective rights in general, and especially we see collective bargaining, they help us to better working conditions. It's simple as main function of collective rights. The second one is there is a huge gap in between bargaining powers of platforms like Amazon.com and an individual worker. So this asymmetry is always handled by collective rights and collective bargaining, and this is especially important for platformers. The third, the whole phenomenon of non-standard work and platform work, they lead to structural inequalities in the labor markets. So collective rights, collective bargaining, it helps balancing these structural inequalities. So the classical functions of collective rights, collective bargaining are just for platform workers. This is the smartest solution for them. And what is extra in this field compared to other non-standard workers, that collective rights, collective agreements, they may help to fill legislative gaps which are here due to the lack of detailed regulation in national law, in international law. It may change in the long term, it may change a bit in the long term, but I think this legislative gap filling function is quite relevant in the gig economy. So altogether, why collective rights? Because they're perfect for platform work. Next slide, please. And now I arrived at the question, which collective rights? And I must start with Article 153 of TFEU, which contains limitations on collective rights in two directions, one on personal scope and the other on material scope. So the range of collective rights is limited. If you look at 153, you see information and consultation is possible, but for example, the excluded rights are strike, lockouts, right to association. So material scope is limited. Personal scope is also limited by referring to workers. So only workers are entitled to these rights. So basically, when we talk about collective rights within the EU, within the framework of Article 153, then we focus on the one hand, information and consultation rights, on the other hand, on the right of collective bargaining. So that's the very reason I will turn in the next part, remaining part of my lecture, to the right of collective bargaining, conclusion of collective agreements. I mentioned the limitation on the personal scope, which is focused on the notion of employee, and moved to another notion of worker in the last couple of decades. So all these rights, collective rights, are dependent on the employment status, which started with the employment status of employee, and now slowly moved by the European Court of Justice towards wider personal scope through the notion of worker, as you all know these developments. So I'm not going to stick into this issue now, but turn on the second part of my lecture, please. Next slide. Thank you. The second part will be, and the main part of my lecture will be, the right to collective bargaining in EU law. Next slide, please. Yes, we are back at the Musketeers. They managed. When Richelieu dissolved Musketeers, they suddenly became from employees, they became solo entrepreneurs. But they fight it for being back in the strong employee status. So you can see the scene from the film when they managed to do so. So basically, at this stage, they got back their rights. So my question will be, one for all solution. Is it possible in EU law for non-employees self-employed? And I will focus on ECJ case law from now on. Next slide, please. What is the issue? The issue is, what is the problem? The problem is that there is Article 101 of TFEU, which contains the antitrust rule of the EU. And this excludes price fixing and all what is connected with collective bargaining in principle. And it says that we have two kinds of people. We have employees and undertakings. You are either an employee or an undertaking, no other. Employees, as you will see, are under a special exception from 101. Undertakings are not, on the one hand. On the other hand, we have EU labor law, and there is a strong mismatch between EU antitrust rules and labor law rules, because labor law has moved in the last decades towards the binary model, as you know, from employee and self-employed division, to a more complex picture, identifying a gray zone in between the two. So the notion of worker is basically mirrors these developments. So we have EU antitrust law, which says that you are either an employee or an undertaking, and we have EU labor law, which says that the picture is more complex and the employee notion is wider by exploiting the notion of worker. So the question is, what is the scope of exception from 101? Next slide, please. The starting decision was the Albany decision, which contained the so-called Albany formula, or we can call it Albany exception. It had two conditions: to have a collective agreement exempted from 101 of the FEU. Condition one, that it should be an agreement of employers and employees, in other words, management and labor, and it has to improve working conditions. The second is clear, the first is problematic. The first is problematic because Albany did not exclude non-employees from the right of collective bargaining explicitly. Pavlov did. It said, the next decision, Pavlov decision, it did because it said that only employees can conclude collective agreements. And if we move on to the next slide, please, then we arrived at the great development. Elizabeth has already mentioned it quite a lot of times. It's a quite famous decision, Dutch case. In this case, the European Court introduced a new notion for self-employed. Of course, everybody knew it before. But in EU law, it said that for self-employed persons, they are workers, employees, can easily say, if they comply with the following 3 tests. These 3 tests are well known from national law. Direction and control in terms of time, place, and contents of work. The second test is so-called economic integration test. So workers are integrated into the employer's organization, they form part of it. Third, the so-called economic dependence or economic reality test. So the worker is not bearing financial risks and her independence is simply notional. So we have 3 tests which are relied on by the European Court by saying that if you comply with these 3 tests, then you are a full self-employed, so you have the right as a worker, for example, have the rights in EU directives. So you belong to the personal scope. Next slide, please. My problem is that Constant has 2 readings. It may have 2 readings. A strict restrictive reading on the left of the slide and more allowing, more flexible reading, what we use it, what we like to use for, that's on the right side of the slide. So if we stick to the strict control test, then all 3 criteria must be applied at the same time strictly. But the core element of this complex test is subordination control, which has already been mentioned in the 𝐂𝐿𝑖 decision of the European Court. So it would lead to an interpretation that only employees and for self-employed, so misclassified employees would have the right to collective bargaining. So it means a very small proportion of platform workers. So this is a very restrictive reading of Constant. If we go on the right side to the economic dependence reading of Constant, then we put the focus on economic dependence, relax a little bit our tests concerning the other 2, subordination control. And if you look at subordination, personal subordination, then we apply the interpretation used by the European Court in Danossa, Bakaja, LMB cases, when subordination, the interpretation of subordination was watered down by focusing on coordination and allowing the existence of subordination by proving coordination in case of board members. So Danossa Bakaja gives us a more flexible approach and basis for this test. What is the result of the second test? It would include economically dependent workers in the notion of worker. Next slide, please. So there are 3 notions. My first question is whether the Constant interpretation, it applies only to collective bargaining or it belongs to the wider notion of worker. I think the second, it belongs to the wider notion of worker. Second question, are for self-employed persons a 3rd category? I don't think so. I think they are used, the for self-employed notion is used to widen the scope of the worker notion. And this is a case-by-case development story. Next slide, please. I'm getting close to the end. Give me just 2 more minutes, please. We promised new perspectives in the title of the conference. This is a new perspective using the so-called Gebhardt formula from '94, which was used regarding the freedom of establishment. There were restrictions on the freedom of establishment, and there was a test developed by the European Court. If there is, the question is about the sound functioning of the single market concerning the exercise of freedoms, or in this case, competition rules, then the Gebhardt formula could be used. And this test could be used, in my view, for and regarding the derogation to Article 101. If you look at the next slide please. Can I have the next slide, please? Could you please turn on the next slide, please? Thank you. So the Gebhardt formula, if you look at this decision, then you see there are basically four conditions you have to comply with. So if you look at the question whether right to collective bargaining for self-employed, does it comply with EU law? First question is, does it have a legitimate objective justified by public interest? I think in case of collective bargaining for self-employed, it does exist. Just have a look at Charter of Fundamental Rights and many other EU documents. Does it secure the attainment of the objective? Yes, because it attains better working conditions. And the third, the proportionality test provides flexibility and restrictions of the right to collective bargaining. So my new perspective would be the application of the Gebhardt formula, which would guarantee a wider exception, an easier general exception from Article 101 of the FEU. Next slide, please. Can I have the next slide, please? And now I come to conclusions on the next slide. Next slide, please. I come to very short conclusions. There are many and very special obstacles to collective rights and collective bargaining for platform workers in EU law. And I focused on collective agreements because they are a perfect method to improve working conditions and so on. The problem is that there is a mismatch between labor law and competition law concepts. How to solve this mismatch and this collision? One solution is a case-by-case development of the EU worker notion, like the constant case, or the application or exploitation of the Gebhardt formula, which seems to be a more radical and easier way out. Next slide, please. But we have more than musketeers. In Oslo, the Fudor Riders, and we had the pleasure to have their representative in our last pre-COVID meeting in Lund. It was a wonderful meeting. It would be nice to meet you again. Lovely to be here. Thank you. Next slide, please. Thank you, Franz.
I think I speak for all the participants to give you all our gratitude, and certainly in the future you will be called Tamás D'Artagnan Gyulahvári as one of the musketeers for collective bargaining for platform workers and gig workers on the European level. Thank you so much for your presentation. As I told, we'll come back later to a discussion, to a debate about the lectures that we heard. And I'm very glad to introduce now Piera Loi, and it's only for the sake of the interpreters that I refrain from welcoming you in Italian, which would be my pleasure. So happy to see you again. We have met for the last time on a very special occasion in February 2020, and since then we are more or less locked down. So I'm really happy to have you here and to listen to your presentation about the boundaries between collective agreements and statutory legislation in the gig economy. Piera speaks to us from her home university, the Università degli Studi di Cagliari. Benvenuta.
Thank you, Franz. It's a pleasure, of course, to be here. But at the same time, I'm a bit sad of not being in Santiago with all my friends and colleagues. But anyway, these are the times that we have to leave. If the slides, otherwise I'll go on. If you want to show my slides, otherwise I will go on. The second one, please. The next one, yes, thank you. It should be clear that digital platform work is a phenomenon that needs to be regulated. The question is with which source of regulation we have to regulate it. Statutory legislation or collective agreement. First of all, the question is even before that. So we need new sources. The legal systems have to adopt new legal sources, or they have to adapt the existing regulatory apparatus. So this is a first set of questions. And the second set of questions is how the relationship between legislation and collective agreements have changed, regulating this phenomenon of digital platform work. And another question is, have supranational sources an influence in defining the boundaries between statutory legislation and collective agreement? These are first set of questions. I will not, of course, give definite answers, but I will try to. Second slide, please. Yes, okay. This is not a comparative study, of course. I just give some examples to show my basic ideas. So don't expect a complete comparative analysis. But anyway, we could find some common trends in the EU member states. First of all, the aphasia of legislators about digital platform work, with some exceptions. A judicial activism of national courts on digital platform classification, workers' classification, and then a very slow but constant collective agreement expansion. The question is, this expansion of collective agreements is independent or is it driven by legislation? So next slide, please. I will try to give first of all, some of the reason of the aphasia of the legislatory member states. Why such a small number of statutory legislation as far as digital platform work? First of all, maybe because there is the idea that no new legislation is really needed. And the set of legal rules existing just need a process of adaptation. This is linked, of course, to the idea that the idea of the completeness of law. Another possible explanation of the aphasia of legislator is that statutory legislation seems to be incapable of following the rapid changes introduced by digital technologies in working places. And then it's better to leave the regulatory space to other residual lawmaking powers like collective agreements and also case law. And then third, I think that there is also a doctrinal position trying to demonstrate that digital platform work is nothing but new, and it's just a modern form, a modern way of Taylorism. Next slides, please. So these are the reasons for not adopting, for the aphasia, explaining the aphasia of legislator. Whereas there are some reasons that explain why some legislators has intervened. First of all, of course, the idea that this is a new phenomenon, digital platform work is a new phenomenon, and especially I quote here the Spanish case, the Spanish Real Decreto Ley, a very recent one of May 2021, following a social dialogue agreement, where it's clearly said that there is a novelty in this phenomenon, and the novelty is the is in the métodos de cálculo matemáticos or algoritmos. So the novelty of this phenomenon is the use of algorithms. And that's why it needs to be regulated also by legislation. At least the Spanish case explained this. And what is important in my view to underline is that they, in this legislation, they say that the original aim of labor law has not changed, and it's related to the need of rebalancing the different interests inside the relationship, the working relationship. Next slide, please. Next. About the models of legislation, I would say that in some cases, digital platform work is very detailed and tailored to the case to be regulated, and has not a general scope of application. For example, Italian legislation of 2019, law number 128, has a very narrow scope of application. It's limited to a very specific category of digital platform workers, the so-called riders or couriers delivering food. And also in Portugal, the law of 2018 on transport services, it applies exclusively to taxi drivers working for digital platforms. Next, please. Next. Whereas we have some other examples of legislation on digital platform work with a very general scope of application. The one I quoted is not from Europe, it's from Chile. From Chile is a legislation which has not been approved yet, but it will be soon approved, I think. And it regulates the employment contracts between both employees and self-employed and digital platform offering services, defining, of course, rights of for both employees and self-employed in digital platform work. Next. Also, another reasoning about the models of the legislation, some legislators have adopted legislation on digital platform worker status, like, for example, the Spanish case with legal presumption, like the Spanish Real Decreto Ley, where there is a legal presumption of subordination, or the Portuguese doing the same thing, so introducing a legal presumption of subordination. So they intervene directly into the issue of workers' classification. Next, please. But other models of legislation are very important in my view, because they try to open a path towards the definition of a common level of social rights for both employees and independent workers in working for digital platform work. It seems that they take as granted the idea that they both, either employees and self-employed, they are both exposed to the same categories of risk, of social risks, when they work for digital platforms. So the wage risk, for example, the opacity of calculation methods, the health and security risks, the data protection risks, the vocational training risks, the social security risks. These are categories of risks to which both employees and independent workers are exposed when they're working for digital platform work. So common risks need to be protected by common fundamental social risks. And I will give you some examples of these pieces of legislation which start from this idea of finding a common path of regulation for both employees and self-employed workers working for digital platform. Next, please. Actually, even if it has a narrow scope, I think that the loi travail in France is in that direction. It starts, at least, to go towards the direction. These pieces of legislation, could be applied to independent workers that use digital platform for the exercise of their professional activity. And there is not a legal presumption that they are independent workers. They also could be employees, but it is applied to independent workers, and a social responsibility is set of digital platform in this case, and there is also an obligation of vocational training for independent digital platform workers, but I will not go into detail, of course. It will be, next please, it will be analyzed by the next sessions. Next please. Also Italy, the Italian example go towards this direction, because for example the law of 29 number 128 sets a level of minimum rights for independent couriers. So it's a very specific intervention. It's like a surgical intervention, but it's the principle is anyway it's interesting because it's to all the riders or couriers, independent riders, there are minimum rights granted, like for example written contract, minimum wage set by collective agreements signed by comparatively most representative unions, 10% plus of compensation for night work and for public holidays, non-discrimination rights in accessing or in being excluded from the digital platform, personal data protection, and insurance for accidents. Next, please. So these are rights for independent couriers. But in some cases, we also find, like the Spanish case, legislation based on general principles, like, for example, the right to be informed the right to be informed of worker representatives about the parameters, the rules and instructions on which the algorithms or artificial intelligence systems are based. So there is a fundamental right to be informed, recognized to workers' representatives, I would say independently from the fact that the workers are employees or self-employed. Yes, next please. Next. Jose Maria told us to use the word vassallo, but I wouldn't use it. Next, okay, the question. Now let's see what are about the relationship between law, legislation, and collective agreement. Normally, traditionally, legislation has played a role of an auxiliary role towards collective agreement. I wonder if this role is still valid, if it's still useful, if it's valid, because it seems that in some cases legislation is, on the contrary, is raising some obstacles to collective agreements. One is the obstacle of representativeness, and often collective actors signing collective agreements for platform workers are considered as non-representatives by the states. For example, I can quote the collective agreements between Assodeliveri and UGL in Italy, regulating working conditions of independent couriers, and the Ministry of Labor has considered the collective agreement not valid since it has been signed by a union non-representative at national level, like the legislation regulating all these activities, the courier activities, was setting. So the question of representatives is a very crucial issue, in my opinion. Next, I have to run, but of course, also the question of classification is an issue. So when the legislation, as it has been said before, legislation set some criteria, like being for collective agreement, like being applied only to employees. This is an obstacle for collective agreements, for example, for digital platform workers who are not employees. Next, please. Next. I have to go very fast, I'm sorry. Another question, another possible obstacle represented by legislation for collective agreements is the territorial scope of national statutory legislation. Because in many cases, national legislation couldn't be helpful, could be supportive for collective agreement when digital platforms operate at transnational level, because they are truly multinational companies. So national legislation could not support collective agreements because at transnational level, because they need to be at transnational level. So we need a different kind of legislation. We need a different kind of legislation supporting collective agreement at a transnational level. I wonder if the model of the European Works Council Directive could be the right one. Next, please. So the question again is how to reconceive or the traditional auxiliary function of legislation towards collective agreement in digital platform work. Many things have been said in the previous interventions. First of all, we need to recognize clearly the right to collective bargaining and other, of course, social rights to digital platform work independently from their classification. Otherwise, we will diminish the regulatory function of collective agreements. And to this end, next, please. It's important. To next, I will say something about it. Okay, thank you. We will need the support of supranational sources, legal sources, to guarantee that collective agreement is really receive this auxiliary function from legislation. And these legal sources, I will not go into detail because it's a job of another estimate colleague. So I would leave it of Barbara Krasal, but of course it's very important the role of the European Social Charter, and also next please, is very important the role that the European Commission with its initiatives will play on this issue, enabling trying to enable collective agreements both for employees and self-employed person. I'm going to my last slide now. Yes, it seems that, of course, collective agreements is the most flexible and adaptable source of regulation, but for platform work, but it still needs the support of other regulatory sources. First of all, statutory legislation that should be reset, trying to avoid all these pitfalls that I hope I have highlighted. And we need legislation at transnational level because also collective agreements should be, in many cases, at transnational level. And we should not forget also the auxiliary role of case law, which in many cases has played a fundamental role in giving strength and supporting collective bargaining on digital platform work. Thank you very much. Sorry, 3 minutes more.
Yeah, thank you very much for your brilliant presentation, which highlighted all the interdependencies between national law, collective bargaining agreements, and international law. There will be a lot of inspiring ideas for a debate, maybe a debate that we can't have in an exhausting way today, but we are on Twitter and we can communicate easily. So the next presentation will be given by Barbara Krasal from the law faculty of the University of Ljubljana. She is a very, very close expert to the social charter, as we have already heard today, and she will give us a presentation about collective bargaining in the gig economy and the European Social Charter. Barbara, very warm welcome to you as well, and the floor is yours. Barbara, you should please open the micro. We can't hear you.
Oh.
I cannot hear you.
You can't hear me?
Good.
Can you hear me now? It seems that we have technical problems.
Technical problems
Can you hear
anymore.
me?
We can hear you. There are no technical problems anymore. Please start.
Okay, thank you then. Can I get my PowerPoint presentation? Okay, thank you very much. So, yes, the aim of my presentation today is to shed light on the topic of this conference, that is collective bargaining in the gig economy, platform economy, from the perspective of the European Social Charter. So my starting question is, what can the European Social Charter add to the discussion on collective bargaining in the gig economy? And the answer is clear and simple: the human rights perspective. The next slide, please. So the right to collective bargaining is a human right. It is enshrined in Article 6 of the European Social Charter. The same text in the original. No, please go back. So we look quickly at the text of Article 6. We see that according to Article 6 of the Charter, with a view to ensuring the effective exercise of the right to bargain collectively, the parties undertake, paragraph 2, to promote machinery for voluntary negotiations between employers organizations, and workers' organizations, with a view to the regulation of terms and conditions of employment by means of collective agreements. Let me draw your attention also to paragraph 4 of Article 6, which guarantees the right to collective action, including the right to strike. So, collective bargaining, together with the right to strike, enshrined in Article 6 of the Charter, and the right to organize, which is enshrined in a separate Article 5 of the Charter. These are strongly interconnected issues, inseparable, essential. These are fundamental labor rights. There is no effective collective bargaining without the right to strike, collective action. And collective bargaining is really an essential element of and inextricably linked to the right to organize, the right to form and join trade unions. At the same time, collective bargaining represents an essential basis for the fulfillment of all other fundamental labor rights guaranteed by the Charter, namely the right to fair remuneration, Article 4, and more generally, right to just conditions of work, Article 2, safe and healthy working conditions, Article 3, and so on, not to explicitly mention all of them. That is, collective labor rights, right to organize, to bargain collectively, together with the right to strike, collective action, function as a correction to the imbalance of power between the employers and the workers, between the capital and the labor, and enables the fulfillment of all other labor rights and the concept of decent work in practice. Without collective bargaining, trade union activities supported by the right to strike, the workers are merely weak individuals that compete with each other for jobs, gigs, by offering their labor under the conditions in which fair remuneration and the overall concept of decent work is seriously threatened or even impossible. And this is equally valid for platform workers, or even more true for platform workers. Please, next slide. The European Social Charter is not alone in this task, guaranteeing the right to collective bargaining as a human right, fundamental labor right. Let me mention International Covenant of Economic, Social, and Cultural Rights, the ILO Fundamental Conventions, in particular numbers 87, 98, Collective bargaining is also protected under Article 11 of the European Convention on Human Rights. Last but not least, let me mention Article 28 of the Charter of Fundamental Rights of the European Union. Workers and employers or their respective organizations have the right to negotiate and conclude collective agreements and to take collective action, including strike action. So we have a lot of international, supranational European instruments, human rights treaties guaranteeing the right to collective bargaining. Today, further on, I will focus on the European Social Charter. Next slide, please. Let me mention that this year, 2021, we celebrate 60 years of the European Social Charter and 25 years of the revised Charter. The Council of Europe's Human Rights Treaty, the so-called Social Constitution of Europe, and important developments occurred in this year. Spain and Germany have ratified the revised charter. Germany in March. It entered into force for Germany on 1st of May this year. In Spain, it ratified the revised charter, accepted also collective complaints procedure in May, less than a month ago. And the revised charter will enter into force for Spain on 1st of July this year. So congratulations for Spain, which hosts today's conference. All in all, 43 state parties are bound by the European Social Charter. And this changes nothing as regards Article 6, paragraph 2, because the right to collective bargaining, the same text is in both versions. So it doesn't matter whether a state party has ratified and is bound by the original or the revised charter as regards the right to collective bargaining. It has to be emphasized that all EU member states accepted and are thus bound by Article 6, paragraph 2 and have to respect it. So all workers and employers have the right to bargain collectively. What does it mean for platform workers, for the gig economy? The answer, again, is clear and simple. Platform workers must not be denied the right to collective bargaining. Next slide, please. It has already been mentioned today. I will not go into detail. Employment status, so where is the problem? The employment status of many platform workers is still quite unclear. Employees, independent contractors, something in between. All in all, I will not go into detail. It is the fact that in practice, most of them are still working as self-employed and often under very precarious working conditions. There is a considerable diversity among them, not a homogeneous group. We have to have this in mind, and high degree of individualization and fragmentation of work, and so on and so on. So there are many legal and practical obstacles for effective realization of their right to collective bargaining in practice. Next slide, please. It is important to stress that collective bargaining requires at least two parties, actors, and employers at workers' side with the ability and will to promote and defend their interests through collective negotiations. Elizabeth has discussed this quite in detail this morning. So who and for whom should negotiate collectively? And collective bargaining requires also an adequate legal framework. National, and I would add also EU legal order, must recognize the right to collective bargaining and promote collective bargaining for all workers. Legal rules in all legal fields, including competition law, and their interpretation and application in practice must be in conformity with the requirements stemming from the legally binding international human rights treaties, including the Charter. Next slide, please. What are these requirements? First of all, and above all, it is important to stress that from the human rights perspective, the formal status of platform workers is not important. The right to collective bargaining must be recognized to platform workers, irrespective of whether they are employees or self-employed workers or have some other intermediate status. So I will not go into detail. It has already been discussed. It will be discussed in detail during this conference. But from the human rights perspective, from the perspective of the European Social Charter, which is, I repeat, binding upon states that have ratified it, from the human rights perspective, the right to collective bargaining must be recognized to platform workers, irrespective of whether they are employees, self-employed workers, something in between. And the case law of the European Committee of Social Rights in this respect is relevant. I must say that it has not dealt with specifically with platform work yet. In collective complaints procedure, the committee has addressed platform work, gig economy, and the last year conclusions published March this year, but not as regards collective bargaining under Article 1, Paragraph 2. Next slide, please. Well, the case law of the European Committee of Social Rights, the supervisory body under the European Social Charter, in this respect is clear. Although the Charter, with one exception, which is not relevant, does not state whether its employment-related provisions applied to the self-employed, and I quote them, the committee has constantly held that in principle, the provisions of Part 2 of the Charter apply to the self-employed, except where the context requires that they be limited to employed persons. No such context obtains in a generalized way for Article 6.2 for collective bargaining. Let me add that similar approach has been taken by the ILO. According to the ILO Committee on Freedom of Association, and I quote, the criterion for determining the person covered by the right to bargain collectively is not based on the existence of an employment relationship, which is often non-existent, for example, in the case of agricultural workers, self-employed workers in general, or those who practice liberal profession, who should nevertheless enjoy the right, and so on. So let me focus on the case law of the European Committee of Social Rights. You have already read this paragraph. It is from the so-called Irish case, which is particularly interesting. It does not concern platform workers. It concerns certain workers deemed self-employed, voiceover actors, musicians, freelance journalists, who were excluded from collective bargaining. So the Irish Competition Authority prohibited certain workers, self-employed workers, from concluding collective agreements. And the complainant organization, Irish Congress of Trade Unions, alleged that such decision of the Competition Authority was in violation of Article 6. So certain categories of workers deemed self-employed were denied the right to bargain collectively. And the European Committee of Social Rights emphasized this, so that these developments must be taken into account as regards the scope of Article 6.2 in respect of self-employed workers. Next slide, please. So self-employed workers should enjoy the right to bargain collectively through organizations that represent them, including in respect of remuneration for services provided, subject only to restrictions provided by law, pursuing legitimate aim, and being necessary in a democratic society. So the proportionality text, only as an exclusion. So collective bargaining should not be treated as an exception under the competition antitrust law, but rather as a fundamental right which can be limited, which can be restricted only as an exception and respecting this proportionality rule. Human rights perspective. So next slide, please. The European Committee of Social Rights also emphasized, among others, that it is not sufficient to rely on distinction between worker and self-employed. The decisive criterion is rather whether there is an imbalance of power between the providers and the engagers of labor, where providers of labor have no substantial influence on the content of contractual conditions. They must be given the possibility of improving the power imbalance for collective bargaining. Next slide. And I would like to add that collective bargaining is an especially important collective labor right and should be effectively guaranteed in practice to all workers, including self-employed workers who personally perform work for another and are not genuine independent contractors. Instead of restricting the right to collective bargaining and impeding its effective implementation in practice also for platform workers, the states should promote collective bargaining for all categories of workers, including platform workers who are in need of such protection. Next slide, please. Yes. Let me finish with a quote from the decision of the European Committee of Social Rights in the post-Laval case collective complaint. Here, the European Committee of Social Rights emphasized that state parties should not interfere in the freedom of trade unions to decide themselves which industrial relationships they wish to regulate in collective agreements, and so on and so on. Trade unions must be allowed to strive for the improvement of existing living and working conditions of workers, and so on. In my view, next slide, please. It is important to analyze the topic of our conference, that is collective bargaining in the gig economy, from the human rights perspective. Given the fundamental rights, human rights character of the right to bargain collectively, being recognized as such in constitutional, European, international law, including the European Social Charter, this right has to be effectively guaranteed also to the platform workers, who are obviously in need of such protection, whereby the actual exercise of the right to collective bargaining in practice should be voluntary and free, and the state should not interfere with it. Collective bargaining should not be dependent on the competition antitrust authorities' decisions. If this is not fulfilled, the essence and strength of free and voluntary autonomous collective bargaining are seriously threatened, and thus the ability to provide decent working conditions to platform workers undermined. There are many issues that can be dealt with, negotiated, and finally regulated by collective agreements for platform workers. There is room in collective agreements for so-called classical contents and digital contents, as Elizabeth already mentioned in her introductory speech. Let me just mention some of them. Yes, minimum rates of pay, remuneration, other classical issues as working time, health and safety, non-discrimination, a highly important issue in combination with transparency and data protection, algorithms, but also issues related to the right to organize, the question of access to virtual premises by trade unions, the right of trade unions to enter the platforms, access to information and consultation, so information and consultation rights of platform workers, and so on and so on. So therefore, it is absolutely necessary that collective bargaining in the gig economy is not just recognized and respected, but also adequately promoted. Thank you for your attention.
Barbara, I do thank you very, very much for bringing in the human rights perspective from the European Social Charter in our discussion and in our project. We still have some 10 minutes for a debate, so I ask you to raise your hand on your computers if you'd like to participate. Is there anyone? Not yet? So may I put a question myself in order to not to waste too much time to Piera. You can hear me, yeah, I see.
Yes, yes, I can hear you.
Piera, you talked about the aphasia of national states to regulate this sector. May one of the explanations be that they are reluctant to create a B class of workers, and so dump out the A class of workers, and in that connection, a question to the Italian legislation, to the courier, to the couriers bringing food. Is it possible for them to claim to be a regular worker, or is this a comprehensive rule? So if you ride with your bicycle and bring food, you are exclusively in such a sector. You cannot claim to be a worker.
Okay, well, I was very, short describing the Italian situation. Actually, I think that the Italian law of 2018 is, as I said, is a surgical intervention of our legislation, and there is not. We could not say that there is a presumption, a legal presumption, for example, of hetero-direction, because hetero-organization, because we have many categories in Italy, not only employees and independent or self-employed. We also have this category of hetero-organized workers. So there isn't a legal presumption. You always need to go before a court and say, well, I want to be, for example, classified as, I think that I am to be classified as an employee or as an hetero-organized. But there is a strong suggestion, I would say, from the legislator to the courts that couriers should be classified at least as hetero-organized workers, and so they deserve all the protections, all the social rights that employees has. Well, as far as your first question, if between the reason of this aphasia of legislators, there is a kind of reluctance of creating a new class, you said.
Yeah, a secondary class.
A secondary
less
class.
protected class, a B class of workers. So when the unions can still hope that these persons would be accepted by the courts as regular workers, so why should they be in favor of a new category that only can bring less protection than the established normal workers?
Yeah. Well, the second category, the third, I would say, category of hetero-organized workers, they deserve all the protection like the first class, the employees. The question is for the self-employed couriers, because the legislation grants them some rights, so they are a kind of pariah of the whole system, where they can decide to keep the minimum rights granted by the law, or either they can go before a court and say, well, you have to reclassify me because I'm not an independent worker, although with some rights, because I am a genuine self-employed. So in the opinion of many scholars, this legislation has not solved the problem, has left everything to the courts again.
Again, yes. Thank you very much.
Thank
Questions
you.
from the public? No questions from the public. Questions from the audience here?
Yeah, also from the panelists, maybe.
Yeah.
Okay, I would like to ask a question to Barbara and ask her if she's convinced that the human right perspective, which of course I agree with, but has no pitfalls. So this is, for example, can Freud maybe wouldn't accept this perspective in defining right to collective agreements?
Well, human rights perspective is a, I would say, legally binding perspective. We have this important human rights treaty ratified by member states, ratified by many states. They are universally recognized, and these are legally binding obligations. Of course, there are problems. We all know that violations of human rights exist, and they will exist. And it's always the question how to implement them, put them into practice, effectively realize them in practice. It is one stone in the mosaic. It is an important argument that can be used by the stakeholders, but at the end, it's always on the stakeholders and let's say stakeholders with power to shape our future, our present and future.
No, I was thinking about
we cannot ignore them. I mean,
yeah, sure. I totally agree with you. But I was thinking about the fact that you were saying correctly that the question is of implementing human rights, of granting their protection in reality. And so maybe I think that we still need the auxiliary function of the law, not simply stating the right, but putting collective actors in the condition of bargaining, of exercising the right. Otherwise, it would be, they are up in the sky, these rights, and on the earth, it happens what happens.
Absolutely. Thank you, Piera, for your words. Definitely. It's always important, not just rights in theory, they must be here and now, practical and effective. So perhaps we should, yes, in the future, focus even more on this, let's say, effective application in practice aspect and instruments that enable effective enforcement of rights in practice, also procedural aspects of the rights, how to implement them, how to enforce them in case of violation. I fully agree with you. I cannot add anything to this. Yes, thank you. And if I may add, also trade unions should use all the fora, also legal fora, not just national, but also international, to realize the rights. Perhaps also through collective complaints procedure under the European Social Charter.
Barbara, I'm very sorry, but we are not in presence here in the discussion. We're limited by time with our Zoom slots, so we have come to an end. Thank you very much. It will be very interesting whether the ECJ will directly apply Article 6, paragraph 4. I rather doubt it, because it's not the source of law that he is strictly bound to. So But thank you very much for all your brilliant presentations, for the short discussion, and we will continue the discussion on Twitter. Thank you very much. The session is closed.
Goodbye. Ciao. See you.
Thank you. See you soon.
See you, Tamas.